I do have the record going, so I'll just start by putting the date on the recording. Today's date is February 10th, 2025, and this is a hearing of some matters in State of Tennessee versus Charlton Liner, docket number 25 CR 297. I guess as an initial matter, I know we have to address a motion to recuse that was filed late on Friday. There was a judicial conference via phone between Mr. Rogers and the state as well, letting the court know that was coming on Friday. And I have obviously reviewed it. And obviously the rules of judicial ethics say that before anything else can happen on this case, we can even get to anything else today, we need to take care of that motion. So obviously the burden of proof on a motion to recuse is on the moving party. And so Mr. Rogers, do you have any proof additionally that you'd like to put on the record?
Yes, Your Honor. I have some exhibits to give to Your Honor for Your Honor to look at as well as some argument that coincides with my motion. I think Your Honor's assessment of the procedural status of why we're here is very clear, and I think it's set out for us by the legislature. I do think Your Honor needs to rule on this motion before anything else. I mimic what I say in the written motion, but I also want Your Honor to hear from me if it's appropriate at this time about certain connections and that sort of thing as a community. As we talked on the phone on the conference call earlier, Your Honor inquired briefly as to why we thought that Your Honor should recuse yourself. And I said, well, Judge, there's many overlapping friends on Facebook. You have a very strong presence online. By virtue probably of your elected position, that's probably a necessary evil of becoming a politician and serving. With that comes also a great responsibility when you are elected to make sure to navigate those things, to make sure that a defendant or a victim in a case receives a fair trial by a judge that's impartial and not attached to any of the parties. When you do a investigatory research on Facebook and social media, even just from one particular account, Facebook, for instance, which I understand is now kind of antiquated compared to some of the others, Your Honor has many overlapping friends. As a practitioner, when you get hired on a case that has some press involved, I know we have press here today that's covering this case. When you have a case that involves prominent or fairly prominent people in the community, you say, okay, what are we to do here? Let's look and see where this case is, who the judge is, who are the people that are involved, and how we're going to go forward. So in this case, obviously, Your Honor is the only judge we have in Bradley County that handles a criminal docket. It was easy for us to decide that Your Honor would be presiding over this case. When you look to social media about the case, you see numerous outpouring of comments, of sympathies, of various things from people from all walks of life. But most importantly, what I noticed, the two most outspoken things came from the victim's employer and from the Rotary Club of Cleveland. When you go look at Your Honor, Judge Collins' accounts online, you realize really quickly that Your Honor is part of that Rotary Club, which is a very fine organization by any standard, I would suggest. And you find that the victim of this alleged case is also part of that organization. I know Your Honor told us on the conference call that you didn't have a personal relationship with Ms. Liner, and I totally believe that. There are connections, however, that make it personal for Your Honor. For instance, when you look at the, if I may approach, Exhibit 1 to this hearing is a print-off from the Rotary Club of Cleveland's post about the very incident that Your Honor is tasked with making crucial decisions on. In that post, many mutual friends that Your Honor has on social media have shared the post and made comments, and some of those are attached to that. We don't know whether Your Honor has seen those or looked at those whatsoever or not. When you look at Your Honor's social media account, you find out quickly that Your Honor, Exhibit number 2, is a member of the Cleveland Rotary Club. Exhibit number 2. Your Honor expresses gratitude for being nominated to that position, for becoming a member, allowing them to let you be a part of that club, which is a very intimate thing. It's a joining together of people in the community for a common purpose or goal. It's called a club for a reason. Your Honor's part of the same club.
How many people are in the Rotary Club of Cleveland? Do you know?
I don't know that as I stand here, Your Honor. Any more questions?
Well, you keep saying intimate, close-knit, but you don't know the number of people in the club?
No, I don't, but I can get to the intimate and close-knit part for you here in just a minute.
Well, I would note for the record, it's around 150 people in the club.
Take judicial notice of that?
Yes.
Okay, all right. 150 people?
Yes. I
Okay.
believe I reached out to Mike Griffin, who is a former president of that club today, to find out. He said, I believe it was 146 with 2 or 3 pending. So that's the size of the club. This time.
May I ask Your Honor, you recently ran an election. Do we know how many people are in the Cleveland community?
120,000, I believe.
120,000 is 150 people in the club, correct?
Correct.
The next exhibit that I'd like to pass up to Your Honor, well, I would ask Your Honor to take notice that in the Facebook post that Your Honor made several years ago when you joined Rotary Club, you acknowledged the sponsorship from Mr. Workman that was your sponsor to the club. Do you agree with, does Your Honor have any problems with that?
No, I know Brian.
Very well. Okay. I do as well. Very nice gentleman. The next thing that you see when you type in this event or the name of the victim on social media, and I passed it up to be marked Exhibit 3 for please the court, is a post from Bender Realty. Bender Realty is evidently where Ms. Liner worked as a real estate agent. Ms. Liner worked under Brian Workman, the sponsor for your Rotary Club nomination. You also look and you type in the names, if I may pass up exhibit number 4. It's a post from Carrie Workman sharing and commenting on the relationship that she had with the victim in this matter. And Ms. Workman is Mr. Workman, Your Honor, sponsor the Rotary Club's wife. Ms. Workman says in her post on social media, which had happened just a day or two after the alleged incident,
Are these exhibits marked before?
From your right
This
to
one's
left.
marked. Are these? No.
that was an
This
exhibit to the motion that I had, so if you want to mark it.
Any objection?
No, Judge, not to any of the exhibits that have been provided.
Number 4 is the one I was talking about where Your Honor sponsors the Rotary Club's wife's commenting on that we just talked to her yesterday in the day or two following the alleged incident. Your Honor's going to have to make decisions on. That shows a closeness of relationship. Your Honor, exhibit number 5, I would tender to the court, is a post made by Your Honor's spouse celebrating Your Honor being elected to the bench 1 year after, I believe, the election, May of 2023, where she thanks a handful of people that is not voluminous. It's maybe 15 or 20 full names. And in that post, Your Honor's spouse thanks Mrs. Workman, Brian Workman's wife, in all her efforts that took place in helping Your Honor get elected. Another close-knit relationship. And exhibit number 6, the final print-off, is a print-off from Mr. Workman, Your Honor's Rotary sponsor, showing that he is in fact the broker and owner that Ms. Liner worked under at Bender Realty. Considering all those things, Your Honor, I know we are trained to set our feelings aside. As I stand here before you, we acknowledge that lawyers have that ability. That's not the standard that we're here about today on a recusal request. The standard is whether a reasonable person would have a reason to believe that Your Honor could not be neutral and detached. With those posts, whether Your Honor can be neutral and detached at all is not our issue. With those posts and those strong real-life club and social media connections, I think puts Your Honor in a position to recuse. Say you ruled in my client's favor. Maybe the state has an opinion about that. But say you continue to deny my client bail, and he's in jail, and he knows about these things, which he does, he or someone from his side or from his family might think, wow, that sure doesn't seem right with all those connections. And that's what we're trying to avoid. We want to build confidence in the system, not questions. And so I ask Your Honor respectfully and humbly to recuse yourself and ask the AOC to appoint someone that is most definitely and can't be argued that they are not neutral and detached. Your Honor is attached because of these connections.
Solely through the Workmen's and Rotary, is that the allegation?
Whatever other social media connections that you have.
All right. Does the state have anything with regards to the recusal motion that they would like to argue, put on the record, anything of that nature?
Judge, we do not have any evidence as the burden is on the defense. The state's position would just be that the evidence we have heard today in the state's position does not rise to that standard that is outlined in case law. So our position would be that a reasonable person of ordinary prudence who heard these facts today would not reasonably question your impartiality on this case.
Well, I'm going to go through the law. I'm going to put these posts back up since one of the bases for saying I would have to recuse is that these posts are floating around and when they're introduced to show me, I guess, on the record, their existence. Tennessee litigants are entitled to have a case resolved by fair and impartial judges. I think that goes without saying, and I seek to do that in every case that comes before me. And obviously, if I had any qualms about personal bias in this matter, I would have recused myself on day one. I do not have any qualms as to whether I can remain fair and impartial in this matter. It sounds like defense is arguing through third-party connections, possibly to Mr. Liner or Ms. Liner, that there would be bias. But let's go through some of the law here. I've tried to. I also filed late Friday, so I've spent the better part of the weekend looking into everything, looking into case law. Under longstanding case law, the proponent of a recusal motion bears the burden of establishing that recusal is appropriate and that any alleged acts or bias, prejudice arise from extrajudicial sources rather than from events or observations during the litigation of a case. A judge should not decide to recuse unless the recusal is truly called for under the circumstances. That's a Tennessee appellate case, Rose versus Cookville. Because the judge possesses a duty to serve, which is the Supreme Court case of Adams, states that a duly elected or appointed judge has as much of a duty not to recuse himself, absent a factual basis for doing so, as he does to step aside when recusal is warranted. And that's, again, from Rose. The issue, again, quoting Rose, the issue with respect to recusal is not the convenience of the judge who should agree to recusal only when it is truly required to do so. Accordingly, disqualification is appropriate only if the facts provided what an objectionable, objective, knowledgeable member of the public would find to be a reasonable basis for doubting the judge's impartiality, or less required a judge could abdicate in different cases at the mere sound of controversy, or a litigant could avoid adverse decisions by alleging the slightest of factual bases for bias, the price of avoiding any hint of impropriety, no matter how fleeting, would grant litigants the power to veto the assignment of judges. And that's all from Rose, those quotes. In looking at these exhibits, the key contention obviously is that I do know the Workmans, who I guess through these exhibits, Miss Liner worked for. I do know the Workmans. I would say they are family friends, and as far as being close friends, I think I have seen Brian twice in the last calendar year. So I think that would be a tenuous argument at best to say, because I know the Workmans and my wife is friends with Carrie Workman, that would necessarily show impropriety on the court's part to continue in this position that I've been elected to fulfill. I can state on the record, matter of factly, I do not know Mr. Liner. I do not know Miss Liner. I went back since the arraignment and since the recusal motion to think, is there ever a time that I even interacted with either of the Liners? I cannot recall a time that I have interacted with the Liners. I'm jogging my memory. I think I have seen Miss Liner twice that I can recall. Once, I believe it was with Mr. Liner at a food truck event in a neighborhood about 4 years ago. And another time I've seen Miss Liner was across the room at Rotary with 100 people present. I've never talked to Ms. Liner. I've never talked to Mr. Liner. Those are the only two times that I can remember in my entire life that I've had any interactions with these two individuals. As far as the comment about the judge about me having a significant Facebook presence, I think Mr. Rogers did put it well. It is a necessary evil, I think. Some judges have been able to be elected. My good friend Wiley up in McMinn County, I don't think he has a Facebook presence. But I would say, judging from the judges that I'm friends with and that I know in Tennessee, I would say a number of them would agree with me that social media is kind of a necessary evil to be an elected figure. And the advisory opinions that bind these courts, the Tennessee Supreme Court has said numerous times that social media, so long as you're mindful of your ethical obligations, is fine. And I'm quoting directly, social media can be utilized by judges so long as they are mindful of their ethical obligations. As State versus Madden, a Tennessee appellate court case. And the Tennessee Supreme Court has made clear that the Code of Judicial Conduct does not require judges to remain isolated from other members of the bar or from the community. In State versus Ferguson, the Court of Criminal Appeals held that the fact that the trial judges was friends on Facebook with a witness is not sufficient proof that the trial court could not impartially fulfill its duty as a 13th juror. It denied a recusal request, noting that the defendant had not developed the length of the Facebook relationship between the trial court and the witness, the extent of their internet interactions, or the nature of those interactions. There's copious case law regarding social media because it is quite a reason that a lot of motions for recusal have come before judges recently. Let's see. In refusing, in that case, in Ferguson, and I'll have written order that I do put down, we'll have all these cases. The judge put great weight that this witness was presumably one of 1,500 Facebook friends for the judge. Obviously, mutual connections have been alleged, and I would say the court has 5,300 followers on its personal Facebook page, which I have made public, which means instead of having friends on Facebook, I have followers on Facebook. I also have 1,600 on a rarely used judicial page that I have. So thousands of Facebook connections. If I were to remove myself from every single case that comes before me where there is a mutual friendship, I would be not a very good judge in Bradley County, because I would not be a judge very often, because I would dare say most people that come before me have some degree of separation from me, just the nature of being an elected official in a county. I could keep going on. I will put down a written order as to that. I would like to address the Rotary Club, because I do think that's an interesting argument, and I think honestly, there has to be a contention by defense or by any moving party for recusal that it's done in good faith. I doubt that it's done in good faith here. I think it is good to delve into such things before.
I'm sorry, I thought you said you got it.
No, I do not doubt. I do not doubt.
Thank you.
No, I do not doubt. I'd be much more upset, right? But the Rotary Club of Cleveland, like I said this morning, I reached out to Mike Griffin, who was a former president, a friend of mine, and said, Mike, how many people are actually in our club? He told me the number 146 and growing. 2 to 3 more potentially in the next weeks or two would be entered. I will say I have my assistant sitting next to me. Our busiest court date of the week is always Tuesdays. We have Walmart Day on Tuesday. It's just a crowded day. And Tuesday is the day the Rotary Club of Cleveland meets. I think last year I attended about 10 times. I have not attended since the incident alleged in this case has occurred. And like I said, I've seen Ms. Liner at Rotary, from my recollection, only one time, have never talked to her. And so it is something I'm ashamed to put on the record, but I'm not a very good Rotarian. I don't really go to Rotary as often as I would like. And also just the nature of having a life outside of court with 6 children and a wife. I just don't get to Rotary, to the events, the special things. I haven't been to the ball in 3 years. And so I do not think that type of Rotary would prevent me from being impartial in this case. I looked at some case law trying to see if there was anything like that in Tennessee, since Rotary is a statewide and nationwide organization. And I did find, obviously under our ethical rules, we're allowed to be in such civic organizations. I found a case, Van Dyne versus Electronic Innovations. The Court of Criminal Appeals denied a recusal request, even though the trial court and the defendant had served together on a local civic board for over a year. In reaching its decision, the court placed significant weight on the fact that the judge and the defendant had never socialized, and the judge did not know anything of defendant's business interests. I think that case is directly on point here, since I've never talked to Ms. Liner, knew anything about her personal life or professional life. And I think that case is controlling here. There's also numerous other cases I'll put in a written order in this matter. There's Anderson Lumber Company versus Kenny. That's held that a judge attending church with relatives of a principal of a plaintiff did not constitute grounds for recusal. There's Lipa versus Grinder. In that case, the Court of Criminal Appeals in 2013 declined to find grounds for recusal, even though the judge attended the same church as the defendant and referred to him as a quote-unquote good Methodist. In denying recusal, the court held that the contact between the trial court and the defendant did not rise to the level of creating the appearance of impartiality and impropriety. I think here it's even more tenuous to say there's an appearance of impropriety than that, much more. The court noted in Grinder, the legal community and the public at large must accept that judges come to each case with a past, and not every connection between the case at bar and the judge's past can be inflated into reasonable potential for bias. Although the court was unable to find a Tennessee recusal case pertaining specifically to Rotary Club membership, it did find numerous on-point cases from other jurisdictions. For instance, there's a case out of Arizona State versus Condra, out of the Arizona Appellate Court. It denied a recusal request despite the judge and a party to the action being mutual members of Rotary Club and sitting at the same table with 6 other people during Rotary Club's weekly lunch meeting. Similarly, in Mullen versus McDivitt, a New Jersey case, that court denied a recusal request even though the judge and the defendant had previously served together in the Rotary Club. In both those cases, the court noted that no bias or prejudice had been shown by the moving party. When you look at all the reasoning of these cases, I do think that I am able to serve as a judge, and that the burden has not been met today. The people of Bradley County have elected me for this position, and I am going to continue serving them in this matter and in this case as well. So at this point, I am denying the motion to recuse, which leads us into, I believe, issues on bond, obviously, which is what the case was originally set for today. And I will put down a written order denying the motion to recuse, hopefully by the end of the day. Now, when we talked in our judicial conference on Friday about the motion to recuse coming, and also about what would take place today, whether we would have a full-on bond hearing, a preliminary hearing, Ms. Rogers, it sounded like you would possibly need some time to get more witnesses together for such a hearing. Is that correct?
Yes, Your Honor. There are some witnesses that I think I need to bring in, some proof I need to bring to the table in support of my bond motion. That's not to say that Your Honor can't sua sponte set a bond, as Your Honor knows that she obviously can, and then hear our argument if we believe it's unjust or too high at a later time. Also, that's all that.
Okay. The state, and I think in our conference on Friday, we were of the opinion that would probably be the request, would be a little more time to have a preliminary hearing and a bond hearing. I would note just the procedural where we're at today as far as the bond. I arraigned Mr. Liner 2 weeks ago tomorrow, so that was, I've got it, the date written down, the 28th, I believe, is the day I arraigned him. On that day, obviously, Mr. Liner was not represented by Mr. Rogers at that point. Representatives of the Canavas firm were here, and the court was prepared to try to have a bond hearing as soon as possible, talking about even later that week, that Thursday, that Friday, I believe also that the Monday after that, which would have been February 3rd. And this date was also given out as an option to have a full bond hearing. And after talking with Mr. Liner, the representative, Paul Henderson, came back and said that this date was chosen because there's a lot of things, obviously, in any case of this magnitude, to try to get all your ducks in a row for such a hearing. And I understand, Mr. Rogers, talking to you Friday, you had just come onto this case early last week. Is that correct? So,
Early last week on Friday before. I have to look at my record, sure.
so all that to be said, the court, just to go over some law, because obviously I could not do anything ethically prior to ruling on the recusal motion. I did look over the motion in the memorandum in favor of setting a bond that was filed by the defense. So far, the court has not given a bond. I'd like to go over that law quickly and then throw it to both sides, possibly for argument, comment. I do think it is argued well in the motion to set a bond in the memorandum in support of that by defense. Tennessee Code Annotated 4011-102 states, and that's what the court cited on the 28th, that arraignment before trial, all defendants shall be bailable by sufficient sureties except for capital offenses where the proof is evident or the presumption is great. After conviction, defendants are bailable as provided by other statutes. Our Constitution in Article 1, Section 15 also states that all prisoners shall be bailable by sufficient sureties unless the capital offenses when the proof is evident or the presumption great. So in looking through the law this week at that, my ruling at first is this first-degree murder is potentially a capital offense. And there are case law that states that, quoting Shaw versus State, murder in the first degree is a capital offense. It's an old Supreme Court case. And looking throughout multiple definitions this week prior to the motion to recuse being filed, Tennessee has defined a capital crime is defined as one in or for which the death penalty may but need not necessarily be imposed. That's State of Wiggins citing Black's Law Dictionary, and that's adopted by numerous other cases. So the court's reasoning at the arraignment, and again, the 28th was a busy court date. It was not just Mr. Liner's case. We had, I think, 100 or so other cases said that Tuesday. And so the court, first thing was, let's try to get a full bond hearing to set a bond. And the state, I believe, was ready to go on three separate times before today that they had thrown out. They could have a hearing. I would note, when setting a bond, there are a number of things that the defense pointed out in their motion, a number of factors the court has to look at. It's difficult for a court to look at that, especially in the case of this magnitude as far as the allegation, without having a full hearing. One of the factors, and I'm looking at the motion, Mr. Rogers, that you filed in this case, is obviously the nature of the offense and the apparent probability of conviction and the likely sentence. The court has no proof before it to determine that bond factor. To set up bond for a capital offense, it has to have the probability that it could have the death penalty or possibly could. There are, I believe, 19 different aggravating factors to a first-degree murder that could possibly qualify for a death penalty. And without hearing proof, I cannot say 100% one way or the other, or really never 100% in my court, but whether that's a potential or not without having heard the proof. And so that is the reason why I would like to try to speed walk, at least to have a bond hearing, even if we bifurcated and have a bond hearing, preliminary hearing at another time. But I need to hear proof before I'm able, as a judge, to set a bond in this matter. That's the opinion of the court today. Because again, I would hate to set a bond today at a certain amount, hear proof that makes me change it at a preliminary hearing and raise it, lower it. I don't think that's fair to Mr. Liner to make a bond and have a judge sua sponte raise it after hearing more proof, which could happen. So it wouldn't be sua sponte at that point.
I understand that, Your Honor. I think Your Honor's assessment of the law is correct and logical, except for that last remark that Your Honor made, that it wouldn't be fair to the defendant to set him a bond and then raise it or lower it or revoke it at a hearing. It wouldn't be fair to the defendant, from our perspective, to deny bail or bond, waiting on hearing of proof from the state. It's a bailable offense. You can grant bail, as Your Honor saw in homicide and first-degree homicide cases. We did an analysis of the last 10 years of Sessions Court cases, and that information is in our motion. There are bonds set anywhere from, I think, $20,000 or $50,000 up to $1 million Will take from your honor the chance that you revoke the bond or raise it after a hearing. But as he sits before your honor, he's entitled to bail, and that's our position. Because, just as your honor said, you haven't heard any proof. The defendant has the burden of proof on certain things. We just went through that with the recusal motion. The state has the burden of proof on other things. There's no aggravating factors been proved, your honor. In fact, no proof before your honor. This is available defense, available defendant, and we ask that your honor grant him bail.
Judge, the state's response would be one, the only instance of waiting on proof from the state comes from their decision to pick a date. The state was prepared after we had that hearing on January 28th to have a preliminary hearing potentially that week, the next week, and it was Ms. Henderson, not Mr. Rogers, that picked February 10th, but that was at the defense request. Again, the defense has requested a continuance because they wanted to file this motion to recuse. The state has not prolonged this preliminary hearing by any means. We have always been ready to go. As far as being entitled to have a bond, that's just not the case with a capital offense. He could get a bond, but just as he could get a bond, you have the ability to decide that he should not get a bond because it's a capital case. So I don't think that factor is really in the defendant's favor. But speaking of rights, the victim's family has a right to be heard at the bond hearing. That is a right that is guaranteed in the Constitution as it applies to victims of crimes, and they have indicated, at least partially, that they are very much considering testifying via the request that we discussed during our phone call this past Friday. So the state's position would be that this defendant needs to be held without bond until we have a preliminary hearing and or a bond hearing, as the state has been ready to do that since January 28th.
Mr. Rogers, you are requesting time to have a full hearing. What time do you request?
Well, Mr. Coffey from my office is here with my calendar. If I may remark on the general's remarks just then. The position that we would take on it being a capital offense, I would just ask your honor to take a look at our motion. If you look at that Holloway v. Joyner case, Holloway v. Joyner was about what could have been a capital offense. The state just wants to presume, my class presumed innocent, they want to presume that because it's first degree murder, it's a capital offense. It could be, but we don't know that yet. So in the Holloway v. Joyner case, it's an old case, but I quoted it, I think it was 1937 or 40 to 38, that overturned a bond decision. I know your honor's got that. If you want to consider it, you could set a bond anytime between now and when we have a full hearing for proof on the amount of bond, whatever your honor thinks is appropriate. But I thought it was incumbent upon me to point that out once again to your honor. I'm ready with my calendar as well.
I would just note for the record, I think sessions court can be difficult. I've said it many times before on different cases, but you're at the front end for everyone, and looking at what constitutes a capital, whether the death penalty could apply or not. Obviously, our rules say that the death penalty notice, although it's best, I believe it's best from the practitioner standpoint to file it as soon as possible. Really, our statutes say you file it 30 days before trial is enough time, which I think that probably needs to be amended. But given that, I think it's difficult at this phase for the court to know one way or the other, which is why the court wants to have a hearing to set the bond. I don't want to put the state on the spot, but there are 19 different ways that a first-degree murder can become an aggravated first-degree murder. Though first-degree murder seems to aggravate it in and of itself, but under our legislature, they say there are 19 ways for a first-degree murder to become aggravated to life without parole or the death penalty. Does the state believe one of those would be met if proof came in?
Judge, that is an internal office decision that still needs to be made, but I do believe that there is one factor that could be relevant, and that would be that the murder was committed during the perpetration or attempt to perpetrate another felony, and burglary is one of those enumerated felonies in that factor. And I apologize, I don't have that statute in front of me, so I can't tell you the specific number.
That's my point, Your Honor. They haven't even made the decision to call it a capital.
Because we don't have to, Judge, as you just explained, as is very clearly outlined in the law.
When, Mr. Rogers, would you be prepared to have a full bond hearing?
You want a special day or one of your regular days?
I think it would probably be better to have a special day, so we're not mixing in with 100 other things.
I agree. I'll prioritize it as long as my schedule allows, Your Honor. I don't know if Your Honor is usually on the bench on Fridays or not. I'm not down there with you.
I would be able to be any day of the week.
2/21 looks fairly light on my schedule, Your Honor. February 21, Friday.
Yes, if we have to remove child support to another court, we'll do that for this.
I'll be happy to help that.
Okay. So, February 21st, do we want to do it, I guess let's start earlier than later, and then we can go through till all the proof is in for both sides.
9 a.m.
Start at 9 a.m. So February 21st. Now for clarity, I would think this would cover both a preliminary hearing and a bond hearing. Does either side have a reason why they would want to bifurcate such a hearing, since a lot of the proof will go to both things?
No, Judge, the state would prefer to keep it as one hearing for efficiency.
You already give me just a minute.
That's fine.
So,
That's fine.
okay.
Yes, that's fine.
Not co-counsel. Civil attorney. We're okay with having a joint hearing.
Let's do that. My assistant has helped me again. She said we'd still have a normal morning docket that day. Usually our Friday is fairly light as far as the morning docket, so let's begin at 10 a.m. That way we don't have tickets and things coming in when we're trying to have a hearing of this nature. So we'll begin this hearing at 10 a.m. on February 21st. I do think that today, given the severity of the allegation, and given it is a first-degree murder, which can become a capital offense, I'm going to wait till I hear proof to set a bond, given the state has proffered that it may meet one of these statutes, and given the religion of burglary with a potential first-degree murder from that would meet one of the statute for an aggravated first-degree murder. So I am going to remain no bond until we can have a hearing and I can hear everything, and then determine if bond is appropriate given our case law and the statutory constitution. So I will see everyone back here on February 21st at 10 a.m. In the morning, and I assume everyone will be ready that day.
Yes, sir. Thank you.
All right.
Yes.
Yes, sir. Thank you.